Swayam Prabha. Digital India. Educated India.
Section 53, Term of Patent. The term of patent refers to the 20-year term during which the patent is said to be alive by payment of renewal fees and during which the patent can be enforced against third parties. Now, we had already mentioned a patent can be enforced with regard to the rights of a patentee mentioned in section 48. So, if there is any contravention of those rights mentioned in section 48, a patentee can take action to enforce the patent against parties who are violating his rights, but this can happen only during the term of the patent. Because once the patent term expires, the 20-year period expires, the exclusivity granted to the patentee will cease to exist. So, the term of the patent refers to the time during which the patent remains alive, by which we mean the official charges that have to be paid for keeping the patent alive have been paid, and the patent is capable of being enforced against third parties. So, this refers to the 20-year time period from the from the date of application of a patent till the patent expires. So, this refers to the term of a patent. 53(1). Subject to provisions of this Act, the term of every patent granted after the commencement of the Patent Amendment Act 2002 and the term of every patent which has not expired and has not ceased to have effect on the date of such commencement under this Act shall be 20 years from the date of filing of the application for the patent. So, 20-year term is computed from the date of filing of the patent. So, the 20-year period starts from the date of filing of the patent. Explanation. For the purpose of this subsection, the term of a patent in the case of an international application filed under PCT designating India shall be 20 years from the international filing date accorded under PCT, the Patent Cooperation Treaty. So, in the case of PCT, the 20-year period will be from the international filing date. 2. A patent shall cease to have effect notwithstanding anything therein or in this Act on the expiration of the period prescribed for the payment of any renewal fee if the renewal fee is not paid within the prescribed period or within such extended period as may be prescribed. Now, patents remain in effect so long as the renewal fees are paid. So, if the renewal fees are not paid, then the patent will lapse and you cannot enforce a patent that has lapsed due to non-payment of renewal fee. So, the patent shall cease to have effect, which means you cannot enforce a patent in a court of law. When we say a patent shall cease to have effect, it simply means that the patentee cannot file an infringement suit. So, that is the import of ceasing to have effect. So, your ability to file an infringement suit will depend on whether you have kept the patent alive by paying the renewal fees. 4. Notwithstanding anything contained in any other law for the time being enforced on cessation of a patent right due to non-payment of renewal fees or on expiry of the term of the patent, the subject matter covered by the said patent shall not be entitled for any protection. This is what we mentioned. You cannot enforce the patent if the patent has ceased to have an effect due to non-payment of fee or the term has expired. So, the patent shall not be entitled to any protection means you cannot file an infringement suit to enforce the rights under the patent. Rule 80 talks about renewal fees under section 53. 1. To keep a patent in force, the renewal fees specified in the first schedule shall be payable at the expiration of the second year from the date of the patent or any such succeeding year, and the same shall be remitted to the Patent Office before the expiration of the second or succeeding year. Now you saw the word date of a patent. Section 45 deals with date of patent, and the date of the patent shall be the date on which the application for patent was filed. The filing date is the date of the patent. Now date of the patent is relevant for filing the renewal fees. So it is the second year from the date of filing or any succeeding year, and it shall be remitted to the Patent Office before the expiration of that year or the succeeding year. So it has to be paid on a regular basis to keep the patent active or alive. The period of payment 1A, the period of payment of renewal fees so specified in sub rule 1 may be extended to such period not being more than 6 months if the request for such extension of time is made in form 4 with the prescribed fee. Now you could extend the payment of fees by not more than 6 months. You need to take an extension for payment of the fees, then the time within which you can seek an extension is 6 months, and it is done by taking form 4. Form 4 is generally used for seeking time, for extension of time. So you would make a request under form 4. While paying the renewal fee, the number and date of the patent concerned and the year in respect of which the fee is paid shall be quoted. Now this is for administrative purposes. The date and the number of the patent and the year for which you are paying should be quoted. 3. The annual renewal fees payable in respect of 2 or more years may be paid in advance. So there is a provision for paying the renewal fee in advance. You can pay it in advance. 4. The controller shall, after making such inquiry as he may deem necessary, credit any renewal fee and issue a certificate that the fee has been paid. Again, certain administrative measures with regard to payment of fees.